Hi there, welcome. This is the Disability Law Show. Host right here, John Scholes, with me again from Samfiru Tumarkin LLP, the most positively reviewed law firm in the country. Sivan Tumarkin, right there. He's going to answer all your questions today. And on a go-forward basis, you can make that phone call. They're always encouraging you to make that phone call, have a chat, get some information. Don't be mystified by the big bad insurance company. Always reach out and use that phone number, 1-855-821-5900. You can email as well, help@disabilityrights.ca, and just disabilityrights.ca will take you to the firm website. Lots to get through today, some emails, some other things, and 3 common misconceptions about total disability. I love this topic every time we talk about this because people know so little about it. It's a big, scary term, but we'll break that down here in just a bit. But we always start off with the week that was, pal. What do you got?
So, John, this past week I spoke with a very nice gentleman, 56 years old, lives in Calgary, Alberta. And this poor person was in a pretty terrible car accident about a year and a half ago. He was rear-ended. His 2 kids were in the car with him. His wife was in the car with him. The police arrived. They were taken to hospital. He suffered a mild traumatic brain injury. He's recovering now. But in addition to that, he's got tremendous chronic pain all over his body, specifically the back and the neck. Depression now, anxiety. He has not been back to work as a result. He's a PSW, a personal support worker. He's been doing that for over 25 years. So it's a very, very important job, very difficult job. Very demanding job, and he used to earn close to $70,000 a year, and remarkably, he hasn't had any lawyer help him with anything. And I told him, I said, we deal with car accidents in Alberta. We can help people get their Section B benefits. We can help people get pain and suffering, all that kind of stuff. And in addition to that, what I found out is that just recently he was denied his long-term disability claim. And it's one of the more prominent insurance companies that acts in Alberta for individuals. And when he told me why, again, I was just surprised. And it goes to the topic that we're talking about today, which is total disability. The insurance company basically said, we don't believe that you are totally disabled from performing the essential tasks of your own occupation. That's it, period. They didn't explain why. Even though his own doctors, hospital doctors, physiotherapist, I think he was a psychologist, everyone wrote that he's unable to work at this point in time. So you would think this is a no-brainer, right? He has a claim both for his car accident injuries, Section B benefits, as well as long-term disability. And I explained it to him, and I spoke with him, and I spoke with his wife for over an hour and a half. First it was a phone conversation, then we did it by Zoom because they wanted to just have face-to-face. Very, very nice people. You could see that they've been through a lot. They're on the verge of losing their home.
Wow,
their
man.
Kids, one of them is 8 years old, the other one is 14 years old. The 14-year-old actually just recently started working so she can contribute to the household. I mean, it's a terrible situation. I wish I knew about the situation, that I knew them back then when the accident happened. Because guess what? We probably could have already gotten them a lot of money and taken off some of that financial pressure. So again, I'm explaining to people here, John, we do this show each and every week, and we do our radio shows. You are not alone. You are not alone. We are here to help you. Even if you don't hire us to do anything, at least call us so you can get the information that you need. Incidentally, John, he also had questions about his employment, his work situation, so I put him in touch with one of the lawyers, our lawyers in Calgary that deals with employment law. You see, our specialty, our expertise is in employment law, long-term disability law, and personal injury, car accidents, slip and falls, things like that. In different provinces, we can do different things. However, in Alberta, we act on behalf of people who have been injured in car accidents, and we help people with their employment issues and their long-term disability issues. So the way we left it is they're going to think about this, but they're very eager to have us help them. It would be a team of us. It would be myself, someone else from my office, as well as one of our employment lawyers. And I think that we can help them. There's no reason for them to go through this alone. Certainly the insurance company is not going to be able to not pay anything here. They're going to have to pony up. And with respect to the car accident, we will get this family what they deserve in terms of pain and suffering and all the benefits that this person needs to try and get better.
You mentioned all these medical professionals on this team, family doctors, psychologists, so on and so forth, physiotherapists, whatever you mentioned. I mean, they have this file of information, from the doctors, from you guys, or could be coming from you guys. What does the insurance company do? They just fold it into a paper airplane and toss it? How do they ignore that?
You know, it's a good question. You know, sometimes when we look at these denials from insurance companies, we just don't understand where the adjusters are looking.
That's what I mean.
And the reality is, John, I think that you have to, well, the conclusion I've arrived at, and this is my own conclusion, although I can tell you it's shared by many lawyers who do what I do, because we do talk, is that I think insurance companies are just playing the odds. They know what they're doing. They know that they're denying claims wrongly, illegally, unjustifiably. But they're playing the odds that 8 or 9 out of 10 claimants will walk away or give up or play their game, the appeal game. Appeal, deny, appeal, deny, appeal, until you run out the clock, because you only have 2 years to start a legal claim from when you were first denied, with the exception of a few exceptions. Mm-hmm. So, you know, I don't think that insurance companies are doing this blindly. I think that it is organized. I think that it's by design. I think that, because otherwise it makes no sense to me. Insurance companies are very well aware what these claims are worth. They're very well aware that if they had to pay all the legitimate claims out there, they'd be paying billions of dollars. And, you know, we hear about this all the time. You know, remember, every time there's a natural disaster, particularly in the States, and you hear about all these big insurance companies, and you have all the, by the way, with COVID even, forget about that, COVID, right? When we had all these claims come through, people canceled their trip. I mean, you heard me on the news all over the country about the class action that we did, which, by the way, we just recently settled for millions of dollars, for the fact that insurance companies did not pay these cancellation, these trip cancellation claims. So again, you can't let insurance companies get away with this stuff. You can't. But I'm not putting this on people to do this themselves. I'm simply telling you, you have options. We are here to give you this information. Simply contact us. If you don't like what you hear, or even if you do, but you choose not to do anything about it, it's your prerogative, it's your choice. But at least empower yourself. No different than if you have a medical situation, speak to the doctor about what your options are. It's the exact same thing. And then you decide how you want to proceed, but at least get this information.
It's interesting, you know, you mentioned that 8 out of 10 people walk away. It seems like low-hanging fruit for the insurance company. Kick them while they're down. They don't have the energy to fight back against, as you call, the big bad insurance company with all this stacked against them. They're going to be like, I don't have the energy to fight.
You don't. You don't. No. And I'll tell you, I think insurance companies understand this. It factors into their calculations. They have shareholders, or they have whoever it is that they have to pay. They understand how much money is at stake. They also have an army of lawyers, but they don't want to pay those lawyers. I used to be one of those lawyers. I used to be one of those. Yeah. They do not like to pay. You know, one of the dirty little secrets about the insurance industry, if you speak to lawyers who do insurance work on the defense side, they'll tell you that they're getting paid very, very little, because insurance companies are stingy. Sometimes they hire third-party companies to audit their own lawyers' bills.
Damn.
Because they don't want to pay even a cent. It doesn't matter if they have this money. They want to keep that money. So they are betting that people are going to just walk away. And for those they don't, they'll hire some lawyers, but eventually they're going to pay. Now, if they come up against lawyers like us, lawyers who have this insurance knowledge, who have worked for insurance companies, who do this for a living, this is a different ballgame. They understand that they're going to end up paying a lot more down the road, so they want to settle now. That's the difference.
Great website you can also use called pocketemploymentlawyer.ca. It's often, you know, we show it off and we use it on the Employment Law Show, of course, with Lior, your partner. But there is a section on that, rightly so, pocketemploymentlawyer.ca, for disability. How's it work? There
is, because many people who have issues with their long-term disability claims, insurance companies also have employment issues and vice versa. People are having issues with their employers or let go by their employers. It's because they are disabled. They're suffering from an illness or an injury. And so, you know, people have told us before, we want something, for you to create something where, you know, if we don't want to call you or don't want to email you, how can we get this correct information quickly and efficiently and anonymously? Well, we answered the call and we created this Pocket Employment Lawyer. It was actually Lior's idea. I'll give him credit for that. But we decided to also include the long-term disability component of it. So if you go to that website, it's free. Yeah. It's anonymous. And it takes you only a few seconds. You put in a few key pieces of information about your own case, without your number, without your name, no identifying information. You will get within seconds accurate information, accurate information, quick information, and it's anonymous. Now, if at that point you want to contact us, click the button and they'll put you in touch with us. If you don't, close the browser. We will not know that you were there. But you will have a place where you can go to get the information you need.
Again, guys, pocketemploymentlawyer.ca is where you want to go. You can always send along an email to follow up. help@disabilityrights.ca. Let's get to the first one for today's show. Cynthia, this time, writes, she says, I've been on LTD for over 2 years now. After a heart attack and a heart arrhythmia diagnosis, the insurance company has recently been insisting I apply for CPP benefits and requested that my information be shared between my doctor, LTD, and CPP disability. Do I have to apply for CPPD?
You need to apply for CPPD. Do you have to? No one's going to force you to do it, but here's what's going to happen if you don't. The insurance company, most likely, Cynthia, will estimate or guesstimate how much they believe you should be entitled to from CPP disability, and then they'll reduce your monthly LTD benefits accordingly. And that's the reason why insurance companies always tell people to apply for CPP disability. And frankly, it's not a bad idea, because if you get accepted, it makes it that much harder for the insurance company to down the road cut you off disability. Now, in terms of sharing the information, well, I don't necessarily agree with that. I don't think that information like that should be shared. Certainly, whether you get CPPD should be shared with the insurance company, because they're entitled to know. But I don't think there should be just a highway of information opened up between the doctor, the CPP disability office, and the insurance company here. One thing I want to mention here is Cynthia says that she's been on LTD for over 2 years. And the 2 years is an important marker. And we talk about this quite a lot, John. Under most long-term disability policies, to get LTD for the first 2 years, you have to demonstrate with the help of your doctors that you are disabled from performing the essential tasks of your own occupation. Beyond the 2-year mark, the test changes. It goes from your own occupation to any occupation for which you're suited for by training, education, or experience. This is why it's important. Once the insurance company approves you beyond that point, first of all, many insurance companies cut you off before that.
Yep.
And so people need to understand that that's...
Anticipate it.
Anticipate it and give us a call so that we can prepare you for it and tell you what you need to do to either avoid it or how to fight it really quickly. But let's say you got over the hurdle of the 2-year mark. So clearly she did here. The question is what to expect now. Well, the fact that the insurance company is asking her to apply for CPP disability tells me that the insurance company is already preparing for the long haul, because now they want to get that credit for the long term, not to have to pay her whatever CPP disability is going to pay her. So again, so people understand, if you get CPP disability, you don't get that on top of LTD. LTD gets reduced by that amount. So if you get $1,000 from CPP disability, $2,000 from LTD, you're not getting $3,000. Right. You're still getting $2,000, except the LTD is now getting a credit for that $1,000.
Of course they want you to apply. Makes sense.
They want you to apply.
Business-wise.
However, and we haven't talked about this a lot, John, but usually in those kinds of cases, that's when they're going to start looking more closely. Are you complying with treatments recommendations? Are you doing what you're supposed to do under the policy? If they ask you to be seen by one of their assessors, are you putting up a fight? Do they believe at some point that you're ready to go back to work, even though you may not be, and then telling you, we want you to try a return to work program? My point is that the tactics of the insurance company starts changing and being modified after the 2-year mark. So don't think that just because you pass that 2-year mark, which is a difficult passing point, because insurance companies like to cut people off beforehand, don't think that it's game over and now you can just sail all to, till you're 65. No, you have to be on guard, be careful. Insurance companies are going to try and find some way of either cutting you off at some point later or minimizing what they have to pay you.
You've mentioned in the past that CPP disability, to qualify for that, is generally a tougher test. Yeah. So is that not a good thing if you qualify and start getting CPP? If it's a tougher test than your insurance company, they try to cut you off, and you're like, hey, the government still says, look, I'm disabled. You have no right to cut me off.
Well, John, we say it's a tougher test. Insurance companies speak from both sides of their mouths. If we go to a mediation, if the insurance company cuts off our client, before the person becomes our client, obviously, by saying the person is not disabled enough, and yet they are approved for CPP disability, I have heard many insurance companies say, well, CPP disability is not a tougher test. By all means, you can qualify for CPP disability and still not qualify for LTD. Technically, yes, but not on grounds of whether you're disabled enough from working. Because if the government says you're not, that's a pretty good indicator, in my mind at least, that there is good reasons for why the LTD insurer should also be approving. But here's the other thing. Some people who have applied for CPP disability and have been denied CPPD, insurance companies sometimes use that against them and say, aha, the government says you're not disabled enough, so now we're going to cut you off. No, you can't do that. We fight those kinds of claims all the time as well, successfully. The fact that the government denied your claim doesn't mean that the government was correct. And we deal with those CPPD applications, by the way. We help people deal with those kinds of denials successfully as well with the government. But no, if you are denied LTD for any reason, if you are cut off for any reason, if you are forced to do something you don't want to do for any reason, please give us a call. Please contact us. We will tell you what your options are and whether the insurance company is correct in telling you what they're telling you.
We'll take a short break. When we come back, what it means to be, quote signs, totally disabled. That's on the way after that short break. In the meantime, that phone number, use it, 1-855-821-5900, and the email help@disabilityrights.ca. We continue. This is the Disability Law Show. Hang on. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. Disability Law Show. Want to get into our main topic for the show today, and that is, what does totally disabled mean? Misconceptions. 3 common misconceptions about those 2 words and their definition. Number 1, the term totally disabled means complete inability to function in any capacity.
Yeah, let's emphasize misconception.
Yeah.
This is a misconception. And, it really was highlighted to me a few weeks back. I think we talked about this, John, when I visited the home of a psychologist friend of mine, who, when I spoke with her about this, and I said, well, total disability in the context of long-term disability doesn't mean complete inability. Doesn't mean that you have to be completely unable to do anything at home. Doesn't mean that you have to be paralyzed. Doesn't mean that you have to be brain dead. It doesn't mean any of that. It simply means that you cannot perform the essential tasks of your own occupation for the first 2 years, or any occupation for which you're suited for after 2 years. Mm-hmm. And I gave her a very stark example. I said, what if you have a surgeon or a concert violinist who injured their pinky finger? Because of that, they can't perform surgery, or they can't, play the violin. But they can do everything else. They can go to the gym, they can do whatever. But they can't perform that essential task of their occupation, which is the main task of their occupation. They would be considered totally disabled under their LTD policy. Yeah. Just by virtue of their pinky finger being injured and then not being able to do that. So, people need to understand, total disability doesn't mean what you think it means. Why then is it called total disability? Why is the word total there? I think it's by design. I think that the insurance industry has created this to mislead. Now, before insurance companies and adjusters say, wait, that's not what we meant, that's not what, that's not the reason, what other reason can there possibly be for insurance companies to say, or to use the term total? When I say I totaled my car, I mean I totaled my car. It's destroyed. It cannot be repaired. Yeah. So for them to use the word total is misleading, period. They could have simply used another term. Disabled from working. They could have used mildly disabled. They could have said they could have just used anything. They could have called it John disabled, whatever. The point is, by using the word total or totally, they are now imbuing that term. They're trying to confuse people, confuse also doctors. And that's the one thing that I really want to emphasize here. Many doctors are confused by it. Many doctors will tell their patients, don't even bother applying because you're not totally disabled. Yeah. Not understanding what that word means in the context of long-term disability.
It's a conversation ender.
It's a conversation ender, and they don't understand. And we're trying to dispel this myth, but man, it's effective because, words matter. Yeah.
Misconception number 2 is this: the insurance adjuster is the sole determinant of whether a claimant is disabled from working.
Yeah, no, even though it may seem like that, right? Because adjusters are the ones who are, at the end of the day, casting judgment on the medical documentation you provide them. They're not the sole determinant. In fact, I would argue that the main determinant is your doctor or set of doctors or whoever's treating you. They're the ones who know you best. It's not even the insurance company's doctors who, frankly, are hired guns by the insurance. By the way, I spoke with a lawyer recently who called these hired guns that insurance companies, the hired doctors that insurance companies retain, pet doctors. I like that term, pet doctors. But look, insurance adjusters, they may deny your claim, but by no means are they the sole determinant of whether or not you're disabled or not. And the reality is, when people call us and they tell us, I've been denied because of this and that, and they hear contrary advice from us, they don't understand why the insurance company is saying one thing and we're saying something else. Well, because the insurance company has an incentive in denying your claim. At that point, they don't have to pay you, right? Especially if you walk away. So no, they're not the sole determinants. And in fact, I will say to you that when we start the legal process, when insurance companies don't back off, they know that they need to settle the claim with us, or else a judge is going to be the determining factor here. Yeah. And they don't want to go before a judge. In many, many cases where they have gone before judges across the country, they've been hammered. So insurance companies understand that they're not the ones deciding if a person is disabled or not, but for individuals who are disabled, they feel that way.
Third misconception about the terms total disability is this: once the insurance company denies benefits, there is no further recourse.
No, it may seem that way. And in fact, one of the things insurance companies are really good at, and we talked about this with respect to total disability, is misleading. And to me, whenever I see a letter, a denial letter, a rejection letter from the insurance company saying, we've denied your claim for so-and-so reason, and then at the end there is a paragraph or two that talks about appeals, what are they doing now? They are trying to redirect you not into a process that potentially could benefit you by reversing the decision, because these appeals are not designed for that, as much as they tell you that they are. In my opinion, they're designed to simply keep you within the labyrinth that they have built for you. All right? It's the labyrinth of you know, it's like those things where you're trying to find from point A to point B, and it is a labyrinth and you can't find your way out. That's what you feel like when you go through one of these things. And then at the end, they deny that attempt. And they deny it again and again and again. So my point is, there is recourse. The recourse is a legal process, which is what we do. But again, it's not as scary as you think. It's not what you see on TV. It's us starting the legal claim with them. And once we do that, internally, you have to understand, once we get involved, internally within the insurance company, your claim now shifts to a different department. A department who now does damage control. A department who now tries to resolve the claim, because they understand that if they don't, it's going to cost them a lot more money later on.
We'll take a short break, and we're going to go to a website called MyDisabilityQuestions.com. It's a free and anonymous place for you to ask questions for Sivan and his team. That is coming up after a short break right here on the Disability Law Show. Stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back to the Disability Law Show. You want to reach out anytime to Sivan and his team, 1-855-821-5900, help at disabilityrights.ca, or this website called MyDisabilityQuestions.com. We'll get to Paige, first one to write in today. She says, I recently received an email announcing that a new manager who has harassed and bullied me when I worked under them at a previous company would be joining the team. This news triggered a mental breakdown, and my doctor put me off work. I'm under treatment for PTSD and panic attacks. Despite this, my benefits were denied as I was told it was a workplace issue. What can I do?
Very, very unfortunate, Paige. I can tell you we can help you on multiple fronts here. Firstly, let's deal with long-term disability.
Yep.
What the insurance company has done here is something that they do quite often, which is to say it's a workplace issue. And of course, James Fireman, colleague of mine, partner of mine who's on the show sometimes, likes to say long-term disability insurance is not bad boss insurance or bad colleague insurance. It is insurance, disability insurance, if you're disabled. Now, the insurance company, in this case, and in many cases, will say that your disability is situational, meaning it's specific to your situation. The test for disability is, can you perform the essential tasks of your own occupation? Not can you work in the office or the particular office where you're at or with your colleagues. So the question here is, if Paige can work elsewhere in that same occupation, will she be disabled? No, she will not be disabled for the purposes of LTD. But if this triggered the mental breakdown and she's on PTSD, and she has panic attacks. And it doesn't matter if she goes back to this environment or a different environment, she's simply unable to function at work at this point in time, no matter which office she's in, then it's a generalized condition. It's not situational, meaning it's more general than just that specific workplace. In that case, she has a case and the insurance company is incorrect. So we need to understand that. My gut sense here is that it has nothing to do at this point in time with the actual workplace itself. It arose from that. But PTSD, anxiety, those kinds of things, oftentimes when they're triggered, takes time to dissipate with treatments. So realistically, she probably is unable to actually work in her own occupation, no matter where she is. If that is the case, and if her doctors confirm this, well, then the insurance company must pay. And then the other side of this, John, is where Lior comes in, which is employment. Yep. Clearly, there's an employment law issue here. Maybe there is constructive dismissal here. Right? By virtue of the fact that now they have this toxic environment there. Well, what is the interplay between employment law and LTD law? That is something we can do a whole show on, and we've covered this before. But you have to have a firm or a lawyer that can guide you because those two areas interlink. They're not exclusive to each other. If you end up getting some kind of damages from your employer for a constructive dismissal, that could impact your LTD payment. So again, very important here. So Paige, after the show, we can chat. I can put you in touch with one of our employment lawyers as well, or Lior, and we can talk about how to navigate this. But I think you have a case against your insurance company here. We can get you the compensation that you deserve. But also, I think that you may have a claim against your employer if you want to pursue that as well.
We'll get to Tiago here. A quick email before we wrap. Says, my doctor believes I'm ready to return to work, but on a part-time basis and with restrictions in place. After speaking to my boss, I was told I can only return as a full-time employee. If I lose my job, will my benefits be cut off?
Very, very important question as well. So, Tiago, again, we are dealing here with the interplay between employment law and long-term disability. And, of course, on the employment side of things, there is a duty to accommodate. So it's possible your employer has not satisfied that duty to accommodate your part-time status, in which case, again, Lior or someone else on our team can speak with you. On the LTD side, if you lose your job, will your benefits be cut off? No. If you are, in fact, still enrolled in your LTD coverage, if you're getting LTD, and we get this all the time, John, what happens if my company closes down or I get fired or whatever?
Different entity.
If you're already on LTD or in the process of getting LTD, it really doesn't matter for the purposes of you continuing to get that kind of coverage and benefits, what happens with your employer. The only way that this matters is if somehow you get fired or the company goes out of business and they pay you some kind of severance, in which case that can get credited to the insurance company. Right. But you do not lose your benefits. Absolutely not. Now, if you are not on LTD, and then you get fired or the company goes out of business, but you're not on LTD, yeah, you lose the coverage because there's no company there or you're not employed there. But as long as you're already getting LTD, what happens with your company, your employer, should not affect your ability to continue getting LTD, period.
And this could continue potentially till Tiago's 65.
Correct.
If that happens, right?
Sometimes even more than that.
Right.
You know, many people think that the age limit is 65. It depends on the policy. Generally it is, but in some policies it actually goes beyond, can go to 70, 75. So you have to check your own policy and see what coverages you have.
Get a copy of your policy and have a read, right?
For
Send it to you, let you guys have a look
Absolutely.
at it too, right? You got it. That is pretty much it for another show. Thank you for reaching out by email or mydisabilityquestions.com. Both of those are available to you anytime. help@disabilityrights.ca. That's how you do it, help@disabilityrights.ca. Phone number, of course, pick it up, grab the phone, talk to Sivan or a member of his team, always ready to help with the conversation. 1-855-821-5900. And again, disabilityrights.ca, free and anonymous. Use that as often as you like. And we'll catch you next time on the Disability Law Show. Thanks for watching.